Arbor One West versus Dashika Hall.
Good afternoon, Ryan Wojcik, P84535 for the plaintiff. This is a termination.
Can I say something?
Yes, your name?
Dashika Hall.
Okay, what do you want to say?
I've been out that unit. My Section 8 gave me 30 days. I was supposed to be out on 6/30/24. I've been out that unit for about 2 weeks. I've been staying in a hotel Ashley Days Inn. I have not been living there. They have their keys and all. So I'm confused because they sent the pecker out. I even changed my mail.
Hey, ma'am.
Yeah.
Ma'am. This is a termination action to have you removed from the premises. So apparently
I'm not there.
You done?
Yes, I'm done.
Because I'm going to talk now. So apparently that information didn't get to the attorney. So what I'm going to do, they'll check in on it. I'm just going to adjourn it out to the 19th, 2024 at 3 p.m. If everything's set, they've gotten what they want, and this should all get taken care
of. Okay.
And if I may, Your Honor, I would say if Ms. Hall has the time, I would just double check with landlord to make sure that they have everything they need from you. I'll follow up on our end, though, to make sure we don't need anything else. And hopefully we can just dismiss.
Okay.
Thank you.
Thank you.
You're welcome.
Brian Otten versus Jason Dennett.
Yes. Yes,
Hello.
I'm here.
All right. This is a termination of tenancy. Your claim in this case, sir, is, well,
unpaid rent. Again.
Okay, but you can't do it.
July.
You can't do it this way.
Okay.
Either you're seeking, is there a lease on the premises?
There is.
Okay. All of this paperwork, you've got the right notice, I guess, but you're going to have to file a new amended complaint. So I'm going to give you an opportunity to file amended complaint, get it to the defendant, but you got to file that. I'll adjourn this out 1 week for you to accomplish that. So I'm adjourning it out.
What would I need to do to collect the back rent that's now 5 months behind again? We were here last year for the same. We were here last year in front of you for the same issue. He hasn't paid rent for 5 months again.
Okay, but I got to have a proper complaint in front of me before I can even begin to deal with that.
So these are the forms that were given to me at the courthouse. I asked them
what?
These are the forms that were given to me by the clerks when I came to fill out the paperwork.
So it's their fault that you filed the wrong forms.
I asked them what I needed to file. This is what they gave me.
Sir, I have a non-payment of rent notice to quit. I have a termination of tenancy complaint.
Okay.
I don't know. I wasn't there during the conversation. I have the wrong complaint.
Okay, so is there something we can do to get the back rent and I'll have to refile for the
Did you hear anything I just said? You need to file an amended complaint on the right form.
Okay.
I'm giving you a week to do that.
Okay.
And I'm adjourning the matter out to July 19th, 2024.
Okay.
At 2 p.m. You need to serve it. You need to make sure a copy is filed with the court, and you need to serve a copy on the defendant. Thank you.
Wait, yeah. Okay. Go. You hand me my screen box. Now go preach.
Gary Hahn versus Wallace Pitchford.
I'm here, Your Honor. I apologize.
Go ahead and state your appearance.
For the record, Your Honor, Corey Carpenter, P67818, on behalf of the plaintiff, Mr. Hahn. I believe Miss Kim is appearing on behalf of the defendants.
Miss Kim? Min Kim?
Your Honor, what I can tell you is I did speak to Miss Kim last night after she entered her appearance. Without saying too much, obviously, I don't want to say too much on the record, but it seems like this case may be a little more layered than originally thought on my behalf. We had agreed to just adjourn this with the court permission to August 9th, if that was possible. I'm not sure why Ms. Kim isn't on. She might be handling other matters. I'm not sure, but that was the sum and substance of our conversation, and certainly can represent that as an officer of the court.
Ms. Kim is.
Good morning,
I do
Your Honor. I'm sorry, I stepped away. I thought we were like 30 something on the 10 o'clock docket. So I am here representing the estate of Wallace Pitchford. His grandson and daughter, I think, are on the Zoom right now. Marcus Smith and Teresa Smith.
Ms. Smith?
Yes, sir.
Is it Hiram Smith?
Yes, sir.
Okay, so my understanding is this was going to be adjourned.
Yes, Your Honor. I apologize. I didn't hear what Mr. Carpenter said, but we did discuss the matter and parties are requesting 4 weeks adjournment so that we can share some documents. And I am hoping, Your Honor, that plaintiff will voluntarily dismiss the case. There is a land contract involved as well as issue with the real party in interest as the plaintiff.
All right. Let me just say this also in the most delicate way I can. I don't know if this is the same Mr. Hahn who was landlord in Ypsilanti forever and ever.
Yes, Your Honor. It is.
Okay. So, and I'll just put it this way. I am, if the parties dismiss it, then I'd like to know, but I am going to recuse myself. There was a period a while back when Judge Conlon was on the bench, Judge Tabby was on the bench, where Mr. Hahn, through, I think, here, as well as when he was in California through a bankruptcy court, filed suit against the court and all of the judges of the court.
Yes, I recall, Your Honor. He filed suit against myself as well. Yeah.
And so, I'll be honest with you, I don't want anything to do with it. So, because it was all frivolous. And so I am going to recuse myself. Judge Tabby and Judge Conlon are no longer on the bench. However, Judge Barr may have had some issues during the course of his representation of the city of Ypsi vis-a-vis Mr. Hahn. I'm not going to speak for Judge Barr, but I have a feeling that may be it. So it is. So I am going to recuse, and then it is going to have to be set up somehow and or another. And I don't know how long you may get your adjournment in any respect, because it's going to take a bit for that to happen. And then a judge assigned to the case. So I'm recusing. We will be sending the paper to our administration, and then the parties will be notified of a future date.
Thank you, Your Honor. I appreciate it.
Thank you, Your Honor.
Thank you.
Yeah, bye-bye.
Tim Avey versus Cody Tyler.
Yes, I'm here.
Okay, I being who? Oh, Mr.
I'm
Avey.
Tim Avey. Yes.
Thank you. And is the other side here? Cody Tyler, this is a non-payment of rent. Would you like to take a default on this case, sir?
Tell him yes, but we need him out.
Yes, but we need him out. The township is
him out. That's not how it works. You filed a non-payment. Raise your right hand to be sworn.
Yes, sir.
How much are you claiming he owes in rent?
He owes approximately $5,000.
Hold on. Was that last case a 4?
You gotta tell him that.
Was.
It was. Never mind. Okay, we got a problem. Because where did you get the forms that you filed?
From the court, Saline Courthouse.
Sir, you filed a termination case. You're not asking for rent. Is that correct?
Not at this moment. The township, this is a commercial property, and the gentleman moved in, and you're not allowed to live there.
I don't know who's talking. Mr. Avey's lips are not moving.
This is my wife. This is my wife, Kim Avey.
Okay.
She's helping me through this matter.
All right. So is there a lease on the premises, sir? We'll do
No.
it this way.
No,
There's no lease.
no.
And so you're terminating. Let me make sure you gave the right amount of time. Oh my goodness.
Yeah, we did the 30 days and.
All right. Here's the problem. You're trying to get them out.
Yes, the township.
You didn't give 30 days notice.
Yes, we did.
Yes, we did.
No, you didn't.
Oh, okay.
Yes.
But we did.
I'm looking at. All right, everybody wants to correct me, but I'm
No, I'm
looking.
sorry.
Maybe I count wrong.
I'm sorry.
April 27th, 2004 to May 15th, 2024. Emily, you're my calendar. Is that 30 days?
I don't think so.
I don't think so.
All right.
So my calendar's right.
It was, here's the paperwork right here.
I don't know, sir.
April 27th.
Yes, April 27th.
And
then go up the form and look at what date you told them to move out.
30 days. We did 31 days.
Yeah, like 31 days.
What paper are you looking at? I can't see it. I'm going to tell you what I've got. What I've got is a form that says that you must move by May 15th, 2024. And that there's a certification that it was filed and served on, well, this form is all wrong. Because this one says that you certify that it was served a notice on Timothy Avey, which I don't think is who you served it on.
No.
You should have served it on Cody Tyler.
We did.
But I got the wrong person on my form. And it says in any event that you did that on April 27th, 2024. So April has 30 days. So that's 3. The 15th of May, which is the next month following. Help me. That's 18 days.
No,
we waited our 31 days.
Okay, look.
I don't know where that form
I don't know why anybody wants to fight with me. The notice has to have 30 days. It doesn't.
All right, we'll redo it.
You have to, because it also says it was served on you. So the notice is bad. I'm a court of statutory jurisdiction. I don't have a proper notice. Because I don't have a proper notice, this matter's got to be dismissed for lack of subject matter jurisdiction. Case dismissed.
Sir, can I ask you something, sir?
Sure.
We currently are in court with you due to this from Northfield Township. It was adjourned until April 26th at 9 a.m. And you're not allowed to live there. They had Child Protective Services. They had the police down there. So Northfield Township is taking us to court because there's people living in a little shop, in a commercial shop with children and stuff, and no one's allowed to live there because it's a commercial building. So we have to keep coming back to court with you through the township because of these people there that we did not even allow to live.
I don't. Okay, first of all,
he don't care.
And I have a lot of cases, so I don't recognize you. I don't know if you're before me or Judge Freshout.
Okay, meaning? I mean, I have the case number or whatever you need. I don't know what else to tell the township at this point.
Give me the other case number.
The other case number, sir, is 223-0393. Or I'm sorry, 233-0393.
Fresh hour.
It's before Judge Freshour, because that's not even my case code.
Okay.
And that's Northfield Township. What is it?
Yes.
Yes, sir.
It's a blight or some other type of infraction. I don't have anything to do with that.
Okay.
I see what you're trying to do. If they're claiming that there are people that are living there in another matter, the township, you're trying to get them out. What I'm telling you is you did it wrong.
Okay.
Okay. I went to the court and filed exactly what they gave me, what the clerks gave me. They told me the date to wait, which was 31 days. We waited until then and then had him served in person. And it was the 31 days. I was just trying to find that in the paperwork here. I don't think I got a copy. The top copy was the gentleman who actually served him with his information and the date, which was 31 days, 100%. It was actually a few days past that. So I'm not sure where that confusion is.
Well, I know
Yes,
where it's not 31 days from the time you serve them with the notice till you file the complaint. The notice has to give them 31 days.
Correct.
Your notice gives exactly 18.
Okay, I can't find that paper of where he served, but okay. So we have to redo all this again before, and then we'll be back in court there with the township.
Yeah, you'll be right back before me.
Okay.
Miss another day of work.
Yep. We all had to take off work again for this. All right.
Thank you, sir.
Did nothing for us. What are we gonna do now?
Wow. Are we done with that one?
Yeah, I just put them in the waiting
Are
room
they're gone? You put them in the waiting room?
because they were saying stuff.
They were saying stuff? Okay. I don't know what she was looking at. I don't. Lamont Nunn versus Cassandra Thompson.
Good morning, Ryan.
Your name
Cassandra Thompson.
and your name, sir?
Lamont Nunn.
Okay, this is a termination, and Mr. Nunn. Wow. Amended complaint. All right. So first, this is a termination. First question: is there a lease?
No.
No, Your Honor.
Your Honor, I just want to say that I'm not asking for any for judgment in this case, and I will not be accepting any money. I just would like them to move, and that's clear and brief.
Okay. Ms. Thompson, what's your position on that?
I would like to stay in the house. I've been a loyal tenant for him for 6 years now.
Do you have a place to go, or
Not at the moment.
are you going to seek legal assistance, ma'am?
Yes.
All right. I'm going to give you a week adjournment for you to do that. Ma'am, did you get a copy of an amended complaint?
No, she didn't, Your Honor. I did that. They told me to come down. They told me I told them that I checked the wrong box, and so I came down before the day before the hearing. And
yeah, I know, but she's got to have a copy of that. She's got to have a copy of the reasons for the termination. There's also.
Oh, okay. Go ahead.
Okay. Here's the other problem. Ma'am, what did your notice to quit say? Because the notice to quit I have has three different scratched out dates.
That's
and then
what
a
I
date
have,
put in.
Your Honor.
What?
That's what I have, Your Honor. A bunch of scribbles and then another date.
Did you get served one back on May 13th?
I didn't personally get served anything.
Did you get one in the mail?
Yeah, I got envelope in the mail, but there was like no sender or anything. It was just addressed to me. That was it.
Okay, here's what I'm going to do. Sir, you've got to serve the complaint on her. The amended complaint.
Your Honor, they're going to hide and not let me serve them, Your Honor. That's why I have to do it in the mail. They won't let me. They're hiding. So I don't know what else to do, but send it in the mail and send it certified.
You have to do it.
That could be some type of, Your Honor, it says on there I could serve it first class mail address. That's what the county did. They sent it first class mail.
I know what they did.
I'm gonna file a 7-day notice to recover the property. Try to serve her. If not, I'm gonna send it first class mail. That's the best I can do, Your Honor. You're not gonna let me, huh?
I don't. I must be talking French because nobody's listening to me.
No, sir.
Was that a no, sir? That nobody's listening to me, or
no? That's a no, sir. You're not talking French.
Oh, thank you. 'Cause I don't even know. I don't even know French. If I broke into Spanish, that might happen. All right. Look, you filed an amended complaint. You can't file an amended complaint and not serve the other side.
Okay.
So you have to serve the other side with that amended complaint.
Okay.
So I'm giving you time to do that.
Okay.
You guys
Your
have
Honor.
to appear. You guys have to appear in person, July 19th, 2024 at
2 p.m.
2 p.m.
Okay.
In person. Because
Okay.
I got to see this notice to quit thing. There's a notice to quit issue. I am not dealing with that today.
Okay, Your Honor. So do I need to file a 7-day notice to end?
Sir, this is a weird thing about being a judge. I cannot give you legal advice.
Okay.
So I don't know what you're intending upon doing, but I can't advise you as to that. The only thing I can tell you is that you have to follow the court rules.
Okay.
Part of the court rule is that if you file something with the court, the other side gets to see it. So you got to serve that amended complaint on her. What else you do, I can't help you.
Okay. I may have to get an attorney.
Yeah.
All right.
I mean, I didn't mean to say that out loud. All right.
All right. Thank you.
Thank you.
They won.
I'm going to take a recess. I'm going to go back there, get a better mood, and then I'm going to come back out. Okay? Court, they can remain seated. Court stands in recess. Alec Jerome versus Eric Cassidy. Counsel, state your appearances.
Donna Tope, I'm here on behalf of the plaintiffs, Alec Jerome and Caroline Jerome. They are here by Zoom.
Yes, I do see that.
Good afternoon, Your Honor. Francinova appearing on behalf of Eric Cassidy. Gail Rosen from University of Michigan Student Legal Services has filed an appearance on behalf of Paula Cassidy. However, Ms. Rosen is at a conference this week, and so we are proceeding without her presence.
All right. I think the first order of business that we have to take up is before it goes any further, is the motion, I think, filed by Ms. Rosen. So I don't know, counsel, if you were going to, well, who was going to argue that motion? She's not here.
I'm fine arguing the motion, Your Honor.
All right. And counsel, you received a copy of the motion? Okay. I did not get a response to the motion, but
I haven't had a chance to respond, but I will today.
Your Honor, I did also mail the motion on Monday and email it as well.
all right. Well, without here, I've reviewed the motion and I don't need much argument unless somebody wants to argue. I guess, Ms. Tope, I would ask why wouldn't you be disqualified as counsel in this case?
Your Honor, their counter complaint is their complaint or their motion to disqualify me is premature. It's not right. There's no certainty that the cases will go to trial. The plaintiff's right to the legal representation of their choice would be irreparably damaged if their attorney, me, were not there to represent them during the preliminary steps before trial. If the case does go to trial, defendants can make the motion then. The defendants claim in their brief that there is a conflict of interest. A conflict of interest does not exist. I, Donna K. Tope, MSJD, has no legal or personal relationship with the defendants in this case. Donna K. Tope, as plaintiff's property managed agent, has no legal or personal duty or legal relationship with the defendants of any kind. The legal brief is in error. Donna K. Tope, MSJD, me, the plaintiff's attorney, is not a party in any of the Cassidy's legal filings. Their counter complaint is against Alec Jerome, Caroline Jerome, Cambridge Family Holdings Property Management Company, and Donna K. Tope, the Jerome's property management agent. The complaint is a documents case. It is a landlord-tenant case for non-payment of rent and termination of the lease, and that the Cassidys violated several terms of the lease between landlord owners Jerome's and the Cassidys.
Okay, Mr. Let me stop you for a moment.
Mm-hmm.
On some of that, you may be correct, but I think the biggest problem that I see, and there are a number of them, but the biggest problem I see is you representing in a case in which you may be a witness.
And my next point is directly on that point, and that is that the case is based on the Cassidys withholding all rent and utility payments beginning with those due September 1st. The defendant's defense is limited to the legal basis for the claim that those repairs were so egregious and made the home so unlivable so as to rise to remedy of withholding all rent beginning December 1st. There are 4 different witnesses. They have filed the case against Alec Jerome, Caroline Jerome, Cambridge Family Holdings, and Donna K. Tope. All 4 of those people could be witnesses for any of the evidence.
But counsel, that doesn't negate the fact that you could be a witness.
I'm not an essential witness. There are 3 other people.
But hold on. I think that you are, if what's contained in here is correct. And that is that you're having these conversations with the other parties.
I'm having these conversations. Could you be a little more specific?
Well, but you're arranging certain things. You're the one talking to them. You're the one dealing
As
with them.
the agent is okay.
Right. I get it. I get why you're doing it in that capacity. I don't have any issue with that.
I'm just trying to understand.
Right. What I have an issue with are the rules of professional conduct, particularly, and then you representing a party where of rights, because of a conversation that might have ensued, you would be called as the witness. That's a problem.
Okay, the rules of professional conduct, and that is where that is behind what I say that the brief of a conflict of interest does not exist, is because that an attorney in a party to a suit cannot be a witness. I, Donna K. Tope, MSJD, am not a party to any lawsuit that they have filed.
No. But the rule also indicates you can't be the attorney and witness.
The other 3 parties are the best witnesses because they're the landlords.
But counsel, just by being here the number of times that we've been here, what's clear to me is that you're, just by way of example, you've got conversations or have conversations that you've had with the Cassidys directly, with Eric and Paula Cassidy.
Not as an attorney, only as the property management. And they are all related.
Right. But it almost would be better if you had it as the attorney, because that puts you in a different boat. It's precisely what you just said that causes the problem. You are having these conversations, negotiating with them, imploring them, taking their complaint. Hey, hold on.
I'm not negotiating. I'm just managing the property.
Right. But in that management of the property, you're having the conversations with the tenants.
Through their attorneys, always. Now, once these cases began, I do everything through the attorneys as well.
They didn't always have attorneys.
No.
Right? You dealt with them directly.
Neither did the Jeromes.
Miss Tote, I think, let me just be clear about this. I am loath when an attorney comes before the court to disqualify an attorney ever. I just am. I think attorneys, we're in a profession that is in a lot of ways self-governing. So if there is a conflict, I mean, if you just take the basic structure and you say that if I am an attorney in a case and I could be a witness to something in the case, then you almost have to rely upon the attorney not to enter into representation. Now, having said that, and so typically attorneys won't. And so I don't like, because I think attorneys have to make that decision a lot of times on their own, right? And so I don't like to get involved in that. But when it's brought before me that an attorney is going to be a witness in the case, and the other reason I don't like it is because sometimes that can be used from a tactical perspective from one side or the other. And so I went through this in great detail, quite frankly, trying to find a way that would preserve your ability to represent these individuals. That's really how I approach it when I'm reading it, right? Because what I say to myself is, if an attorney isn't supposed to be in a case, the attorney is going to get out of the case. This other side's filing this to get this other attorney out of the case. So I'm going to operate on the presumption that the attorney should be there. When I finish reading this, and then also knowing and having been here and heard the case, I'll be absolutely honest with you. I don't think you can represent the parties in this case, because you are clearly, in my mind, going to be a witness. Now, I'll stop you, hold it before you say anything.
That's if we go to trial.
But here's what I don't want to end up in. But there can be certain points before trial. In the way I operate my cases, where I set them for a final settlement conference,
Right.
and the thing in certain representation.
Yeah, no, I would be acting as their attorney in those pre-trial.
Right. Well, the problem is I may ask for certain representations from the parties. I don't want to.
I understand. I get exactly that. There is a problem there because you would be talking with them from, I get that.
And I don't want to be, so the interesting thing about all lawyers are bound by this, that if I see a violation of the ethical rule,
yeah,
I'm then,
that would be,
hold on, I'm then required to report.
Okay.
So I do not want to be in a position where I have to report you. I don't do that unless I absolutely
Oh, well,
have to. And
thank you very
I
much.
don't want to do that. I wouldn't want to do it to anyone.
So can I just want to suggest that your kinds of reservations, your kinds of concerns would not apply if the Jeromes were representing themselves. And yet they still are going to be witnesses in their counter complaint.
That is absolutely correct.
Okay.
It wouldn't apply to them.
No.
It doesn't.
No, because they're not attorneys under the attorney. Well, I still say that I would like you to wait until we actually come to that Waterloo, but I know that because we may not. I mean, we were hoping that we could get some kind of meeting of the minds at this discussion that occurred without attorneys at the University of Michigan's legal department's dispute resolution meeting that took place. And we did not. But if a settlement does occur before I have to come in a legal court proceeding representing the Jeromes, then I wouldn't have to disqualify myself from advising them.
So I'm going to have, I've been doing this a minute.
Yeah.
And I'm just going to tell you, I'm going to see it on motions. I'm going to see that.
Got it.
This issue get raised.
Got it.
The moment an affidavit's filed.
Yeah.
We're going to have a problem.
Yeah.
Right.
I totally am understanding your issue.
And so I don't want, everybody has a right to have their cases heard expeditiously to get through them. And I just don't think that can happen in this case.
Given what's going on.
Representing them. Because and here's the other part. The other part is this is a summary proceeding and maybe one of the thickest or second thickest I've had this year filed. But summary proceedings operate at a different pace. We operate rather quickly. The moment they file a motion, file an affidavit alleging that you said we got a problem.
Yeah.
And then I have to put it on hold, which is not, quite frankly, in your client's interest. I have to put it on hold, waiting for an attorney to come in to just answer the motion, let alone argue.
Okay.
Because you would place yourself in a quandary by even trying to answer. You follow me?
No, I absolutely.
Okay.
Absolutely. I mean, like an arrow to the heart.
Okay. Well, don't put it that way.
No, I just got to say,
yeah,
that's what it feels like. But
okay,
I totally understand.
All right. So I guess my question is, if you, rather than me even ruling on this motion at this time, but if you were, how long would it take for you to find counsel to substitute in?
I will talk with my clients and we will have a speedy discussion because they are on it. And I can get back to you within several days.
Okay. Hey, well, as this side to the Jeromes, based upon the discussion, I realize you guys aren't lawyers. So did you have any questions with anything that the court was saying or anything that was going on there?
Alec, did you want to? I think it's clear. I think I understand what you've said. Thank you, Judge Simpson. And yeah, we can confer and we'll figure it out. There is always a lawyer present just because of the nature of the tenants, but we'll find another lawyer that will work and won't cause a conflict. I understand that's super important.
Yes. Okay. So, yes, ma'am.
You did understand what she said, that in every situation involving the tenants, there is a lawyer present on their side, because Eric is a lawyer and he has sort of,
Right. And if
he's
and
inserted lawyerly things into the discussion.
I get it. But
Okay.
But if he were representing, quite frankly, he might have a problem if he were to step in and represent even his wife in this. He could certainly represent himself. I mean, he could do that, but that's not what this is.
No.
Right. And I get there's always a lawyer involved. Sometimes you throw a stone, there's a lawyer involved. So
Mr. Cassidy is licensed in the state of Texas, not in the state of Michigan.
State of Texas? My condolences. All right. So, that's it. So I guess, my thought process is to adjourn this out a couple weeks, allow them to substitute an attorney in even before I rule, so that way we're not even trying to do things right now that may cause problems later. But I don't know how you feel about that. We like having you here every couple weeks or so, but
Your Honor, I mean, we really are asking the court to make the decision today. And I think an email that we received last night from Ms. Tope at like 11:30 p.m., coupled with the motion that she filed a few days ago to allow the landlords to repair the property without the tenants present, show how integral she is and what a fact witness she is. She's, in our opinion, the only fact witness. We don't need anybody else. Not to mention the fact that most of our counterclaims are against her individually.
I know.
Emotional distress and whatnot that we're going to file is against her.
I know.
Individually. And she has a clear conflict of interest, because I presume the Jeromes are going to distance themselves from her and say they haven't authorized the behavior that she's been doing on entering onto their property.
And those are all allegations.
I know. And look, folks, maybe my problem with being a judge is I'm a lawyer's judge.
Is what?
I'm a lawyer's judge. I love the practice of law, and I like watching lawyers practice. And where I don't have to enter into having lawyers do the right thing or whatever, and I don't. I think you had Ms. Tope a certain position that she had. We had that brief interaction we just had now. My understanding is that there will be an attorney substituting in. So what I'm going to do is, this is how I'm going to leave it, because I do understand your point, but you have 7 days to file a substitution of attorney. If not, the court will enter an order granting the disqualification of this. Just do it that way. And I'm not going to proceed on anything else until I have different counsel on this side.
Okay, so they would have to refile my motion that to have the tenants vacate while the landlords do.
No, I mean, I'm not going to require them necessarily to refile. They're going to have to sign something for that motion under the court rules, because it has to be their motion.
Okay.
They don't have to absolutely refile it. I'm not.
Excellent.
I mean, there are ways around that notion without causing undue delay.
Yeah.
All right.
Thank you.
So what I will do, and if counsel, if you would prepare the order that there will be a substitution, right?
Yep.
Or that the court will be granting that. So that order needs to be prepared, submitted to the court. I will adjourn this out 2 weeks. And
Judge,
we will come back. And I'm sorry. Yes, ma'am.
I'm being a little sister. My brother has had his hand raised because he did want to also.
Oh, I'm sorry.
That's okay.
I'm sorry. I wasn't looking at that screen.
That's
and I apologize.
totally cool. Totally cool. Okay.
All right.
Alex.
So you said you were being a little sister when you did that?
Speaking up for my
I wasn't speaking up. I did have my
You
hand
know,
raised.
no, it's okay. I have one of those, and you're right. I get him. He's big brothers. We're just quiet until our little sister says, "Gotta say something."
Okay, I'm back.
Go ahead, sir.
Your Honor, the only point of question that I had was related to, we actually came today prepared to make an offer for settlement of the situation related to the payment of all of the back rent, penalties and fees, but absolving the Cassidys of any of the penalty related to the forfeiture or breaking of the lease, which was in the neighborhood of, I believe, $26,000. Does that make a difference in terms of having a discussion or not?
Yeah, no,
ask that the record be stricken on this in terms of any proposed settlement that we have.
yeah, in the court, its head is not. I'm not even dealing with that. The short part of that is you came to try to look to negotiate it. What I'm going to suggest to you is just hold it for a minute in terms of what position you may want to put forth. Let's get other counsel in to do that who can also look at it. And then if that's still your proposal, certainly there'll be time to submit that to the other side.
Yes.
All right, thank you.
We're heard. Alec, you were heard.
All right? Yes. Okay, so what I'm going to do then is I will adjourn this to July 26th. Thank you.
Your Honor.
Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself from.
Oh my God, sirs. Put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.